In the previous video, Doc versus the Chiropractors Board of Queensland, we showed how Kerry Watson of the board of the Greyhound Racing Authority, now known as Racing Queensland, leveraged her connections in the Chiropractors Board of Queensland, now known as the Chiropractors Board of Australia, to set up Doc in a baseless lawsuit for advertising himself as an animal chiropractor, which as it turned out he has every legal right to do. If you've already watched the previous video, you'll know that Doc, despite all odds against him, won the case on the basis of the Chiropractors Board basically tripping over their own feet. But that's what they get for being Kerry Watson's henchman. 2 years before going after Doc for using the term chiropractor in his advertising, the Chiropractors Board had already acknowledged him as an animal chiropractor and had already given him the okay to identify himself as such. But Kerry Watson and the GRA's assault on Doc wasn't done yet. They were ready to do just about anything to silence Doc from exposing the corruption of the greyhound racing industry, so the harassment continued in the form of the false GRA inquiries that kicked off barely 2 months after Doc won the case against the Chiropractors Board. We've already released detailed breakdown videos of the false inquiries, which you can find on our website, phoenixtaskforce.org, and our YouTube channel. But even while the GRA false inquiries were still going on, after they had lost their case against Doc, the Chiropractors Board was still on the attack, with a false statement being released online stating that Doc was found guilty and had lost the case, which all but destroyed Doc's business because the false statement was left posted online for 19 months after Doc had won the case. After finally learning 18 months later about the Chiropractors Board's blatant lies posted on the internet, it became no wonder that business wasn't returning, and Doc wasn't going to stand for it. But he had his work cut out for him, and little did he know that it was going to be non-stop legal games and getting the runaround before he'd even be able to get any real forward momentum in his pursuit of natural justice, which to this day has yet to be delivered. To begin with, Doc's financial standing had been thoroughly decimated with legal costs and having his business basically drawn to a halt. On top of this, having had the threat of 6 years jail time and a $75,000 fine hanging over his head since 2005, as well as having had to fund not only his legal defence against the Chiropractors Board of Queensland, but also his defence against the Greyhound Racing Authority false inquiries, all of this was taking a tremendous toll on Doc's mental and emotional health, to the point of being treated for severe depression by his local GP, the late Dr. Josephine Drew. So in his deteriorated state, while in the midst of dealing with the training of his greyhounds for the upcoming Bundaberg and Cairns Cups, as well as dealing with the GRA's false charges against him and trying to re-establish his business, and dealing with the ongoing harassment including having his dogs poisoned and killed, when Doc's client Lorraine Burkett called him on the 30th of June 2007 to bring to his attention her discovery of defaming statements and comments found online, Doc was understandably distracted and not yet fully able to appreciate the significance of what Lorraine was attempting to convey. After finally winning the case against the Chiropractors Board, all Doc wanted to do was put all that drama behind him, and to prevent reliving that trauma, Doc was very avoidant of anything to do with the case, and so not really listening to what Lorraine was saying from being stressed out and just wanting to get back to training his dogs at the time, Doc told Lorraine to just mail to him whatever it was she'd found, and on the same day she did just that. However, Doc's ability to deal with day-to-day life in a normal manner was severely impeded by his state of mind at the time, to the point where he allowed his unopened mail to pile up for more than a year. It wasn't until the end of October, when another client who had offered to assist Doc with his business and helping him out with office work, that the false statement was discovered in a Google search, having now been posted online since the 17th of April 2007, more than 2 weeks before the not guilty verdict was even handed down in May, and for a further 18 months before finally being brought to Doc's full attention. Not only was the statement completely false in saying that Doc had been found guilty, it was also false in stating that the board had repeatedly attempted to resolve the issue without prosecution, and that it was Doc that had refused to settle things amicably. But the complete opposite was true. Doc had done everything he could to placate the board and avoid going to trial, including changing his business name to exclude any mention of chiropractic, but the board would never reply to his correspondence or return his calls, let alone discuss any possibility of an amicable resolution. From early on, they'd already been moving straight on to pursuing prosecution, so even if Doc had been found guilty, the remaining statements against him would still be completely untrue. So upon realizing why his business hadn't been returning, with such defamatory content being the Google search top results for anything to do with animal chiropractic or his business, Doc wasted no time in taking action to have the statement removed and his name cleared. And from here, it was non-stop legal games, runarounds, delays, and drama that developed into multiple court hearings in the lead up to a defamation suit against the Chiropractors Board. From the start of November, Doc began reaching out to the board, first in a letter of demand for the false statement to be removed, for compensation to be mediated, and for the publishing of a public apology. Then later in November, having received no response, Doc called the OHPRB, that's the Office of Health Practitioners Registration Boards, now known as APRA, the Australian Health Practitioner Regulation Agency. The OHPRB was the governing body of the Chiropractors Board, and it was their own website where the false statement was posted. Doc spoke on the phone to Ian Purcell of the board, who didn't know anything about Doc's letter, and told him that he'd called Doc back, which he never did. And as you can see from this internal correspondence, the board were more concerned with preserving their own public image than taking any action to have the false statement removed. 3 days later, on the 24th of November, having still heard nothing back, Doc wrote again to the board to have the statement taken down. Glenys Bertram of the board responded the following day, but only to say that the issues he was raising were scheduled for consideration at the board's next meeting on the 12th of December. But it had now been 19 months since the false statement was posted online, so Doc wrote back again pushing for the statement to be taken down without delay. By this time, internal movement to address the false statement had finally begun, and the statement was removed later that day. But with delays in search engine caching, Google search results were still showing the defamatory statements, and the board never took any action at all to address this. Instead, in the days that followed, the board was still scrambling to cover their asses, trying to find any angle they could spin to preserve their illusion of integrity, not even responding to Doc to let him know that the statement had been taken down until 5 days later on the 1st of December. But the removal of the statement from the board's website was just one issue. There was still the matter of compensation and a public apology, both of which were yet to be addressed at the board meeting scheduled for the 12th of December. 3 days later on the 4th, Doc wrote to the board asking to know who the executive officer was that would be tabling the issue at the coming meeting, because just like he'd done multiple times in the original case, having every intention of resolving things amicably, Doc wanted to submit his information to the board so it could be raised in support of the issue of compensation during the board meeting of the 12th. But at this point, the board had now cut all lines of direct communication and went straight on the defensive, having enlisted Alan Whiting of Rogers, Barnes and Green Lawyers as their proxy. So on the 8th, 4 days before the meeting, Doc received correspondence from Mr. Whiting advising him that all correspondence for the board was to be routed through him. The day before the meeting rolled around, and Doc still hadn't heard anything back about who would be tabling the issue, so he decided to call the board anonymously to see what he could find out, and the receptionist he spoke with told him that there was no meeting scheduled for the 12th. But regardless, Doc went ahead and had 2 large folders of documentation couriered to their office anyway. To this day, Doc has still never received any feedback on what transpired during the meeting, and as you can see from the redactions in this Freedom of Information Act release of the meeting minutes, the board was not intent on being forthcoming with what was discussed. Although the very next day, the board was reported on by Newsmail Bundaberg as having refused to comment on the case or the meeting when contacted by Newsmail, as the matter was likely to head back to court. As such, it would appear that the board never had any intention of resolving the matter amicably. After numerous fruitless back-and-forth correspondence throughout December, Doc eventually received a second-hand apology from Mr. Whiting on the 23rd of December, saying that the false statement was a draft that had been stored on the board's website by inadvertence, and also that a public apology would be going up on the board's website, which wasn't even posted until some 2 weeks later. No admission of guilt, no mention at all of the matter of Doc's compensation. The apology was short-lived and meagre at best, with no one willing to sign for responsibility, and no mention at all of the falsehoods about Doc's or the board's conduct that were detailed in the false statement. Doc wasn't going to accept such a paltry apology, and so the next day he wrote to the Queensland Ombudsman for antecedents, and the day after that he wrote to the board's Records Management Unit to lodge a privacy complaint and request an internal review in a bid to obtain information that would help him pursue the matter further. But this proved to be fruitless, with the board's privacy officer Coralie Newth responding 4 months later in April that no breach of privacy had occurred and that the use of Doc's name under the circumstances did not constitute a breach of information under Principle 10 of the Privacy Act. Doc decided to try and up the ante by reaching out directly to government and regulatory bodies and the media for support, as he wasn't getting any real traction with the board. Starting in November, Doc wrote to request support from the Honourable Stephen Robertson, Minister for Health, and again on the 11th of December, the day before the board meeting, stating that he'd no choice but to close down his business completely and deregister his business name after realising the futility of all his hard work trying to rebuild his clientele. But the response he received was almost a month later in January the following year, advising that the minister couldn't become involved now that the matter was under evaluation by the board's legal representation and insurers, and instead, Doc was redirected straight back to Jim O'Dempsey of the board, which was pointless because whenever Doc called the board, he was told by reception that they weren't allowed to speak to him. The only way he could get through to Mr. O'Dempsey was to avoid giving his real name, but even then, Mr. O'Dempsey refused to discuss anything with him, and 3 days later, Doc was again told by the board solicitor, Mr. Whiting, to direct all communication through him, regardless of the advice of the minister. Also in December on the 18th, Doc wrote to the Commonwealth Ombudsman and also to the Queensland Ombudsman on the 16th and the 24th, with only the Queensland Ombudsman responding, but not until April the following year, and only to say that they couldn't help as the board had already apologised. This was despite Doc specifically raising with them the issue of the poor strength of the apology. On the 19th of December, Doc emailed the Premier's office, but all he ever received back was the generic order reply and nothing further. On the 21st, Doc emailed the Liberal National Party advising them of his situation, but no support was offered. Doc tried getting the media involved on the 22nd and the 24th. On the 22nd, 26th, and again on the 28th, after receiving a call to say that the query needed to be sent again, Doc wrote to Mr. Mark McArdle, the Shadow Minister for Health, and that was the end of that exchange. So after all that, the only people to actually respond to Doc were the Queensland Ombudsman and the Minister for Health, both of whom it seemed waited until it was the most convenient and opportune time to basically say that it wasn't appropriate for them to become involved. Eventually, in January, Doc was requested by the board's solicitor to provide 3 years of his business documentation and tax returns prior to the publication of the false statement, which still wouldn't have been an accurate reflection of Doc's natural income because it was already suffering massive losses for most of that time from the first court case where Doc had to close all his clinics and stop advertising. Feeling that he wasn't going to be able to resolve this matter on his own, Doc began the search for legal representation. On the 2nd of January, Doc reached out to Compass Law, who said they were unable to take the case on at this time and referred him to Caxton Law. On the same day, Doc contacted Aussie Law, who said, "We are unable to advise you in this matter," and he was referred to Shine Lawyers. From the 12th to the 15th of January, Doc contacted the Queensland Law Society, but they said it was a conflict of interest, and they referred him to Maurice Blackburn, McCrossan, and again Shine Lawyers. Doc called Maurice Blackburn. "Our firm only specialises in personal injury claims," referred to Khan Reedy Hurd. Contacted Q Pilch, now known as Lawright, assistance for public interest cases only. Reached out to Hall Payne Lawyers, no response. Contacted McGinns Wilson, conflict of interest, referred to Queensland Law Society. 20th of January, Gouldson Legal, no response. Suncoast Legal, no response. McCrossan's, no response. Shine Lawyers said it wouldn't be in your best interest to pursue the claim with us at this time. Referred again to the Queensland Law Society. 21st of January, Schultz Toomey O'Brien Lawyers. We do not have the expertise to assist. Referred yet again to the Queensland Law Society. Hunt Lawyers, no response. Khan Reedy Hurd, no response. 12th of February, Baldwin Cartwright. We do not have the expertise to assist. By March, the pickings were becoming very slim. 5th of March, Emery Partners Solicitors, unable to assist. The Law Company, unqualified. 10th of March, David Spain in New South Wales, too busy. 12th of March, Lismore Law, sorry, we don't do Queensland matters. Referred once again to the Queensland Law Society. If you've seen just about any of our previous videos, you would know of Doc having been unofficially banned from having legal representation by retired Chief Justice Wayne Martin, who we've shown numerous times now, coming to light in 2016, was threatening disbarment for taking on Doc's case, and this slew of failed attempts to acquire legal representation shows just how far back this threat could have been perpetrated. So things were not looking good for Doc in the hunt for a solicitor. By February, after the apology had been in place for a month, weak as it was, Doc decided to re-register his business name and get back on the horse to see if he could reinstate his business. Determined never to give up the fight, on the 15th of March, Doc contacted Gouldson Legal again, who referred him to Peter Boyce of Butler McDermott Lawyers. It seemed that Doc had finally been referred to someone who was willing to take on his case, but as things turned out, it was too good to be true. On the 21st of May, Peter Boyce advised Doc that the statute of limitations to sue for defamation, which was 12 months, had expired, but this was entirely untrue. When the false statement was discovered by one of Doc's clients at the end of October in 2008, according to the Defamation Act, this constituted a publication, and a new limitation period had begun, putting Doc well within the time limit to initiate proceedings against the board for defamation. But as the date of publication was interpreted to be the same as the date it was posted onto the board's website in April of 2007, Doc was instead advised that he must apply for an extension of time before he could initiate proceedings, and this wasn't the only area in which Butler McDermott Lawyers failed in its representation of Doc. Now, the criteria for a successful application for the extension of a limitation period is that the applicant can prove that it wasn't reasonable to commence proceedings within the limitation period. When Doc first made contact with Peter Boyce, he wasn't yet in a position to afford the legal fees they were proposing, so he spent the time from April to December to gather funds for his application to extend the limitation of time. When the application was first heard in court at Maroochydore on the 18th of December 2009, Doc's legal counsel was proceeding on the basis that the original date of publication was the 17th of April 2007. In an effort to reduce the amount of time elapsed that Doc could sue for damages, the board's counsel argued that the date of publication was in fact October 2008, when Doc's client discovered the false statement online, which was technically correct. This date of publication should have been the position of Doc's legal advice from Peter Boyce right from the start, but it wasn't, and as a result, the proceedings of the application dragged on needlessly, with the matter being adjourned to allow the judge time to get up to speed on precedent, while allowing Doc's counsel to file further argument. 5 months later, on the 7th of April 2010, the matter resumed in court. This time, Doc's counsel attempted to prove that the publication could be established as early as June 30, 2007, when Doc's client Lorraine Burkett had called him to let him know about the false statement she'd found online, which we already explained Doc wasn't in any state of mind to properly receive or appreciate. This move did not have the intended effect and ended up backfiring, because the board's counsel was then able to argue that Doc had been aware of the publication since June of 2007, instead of when he actually became aware of it in October 2008. Thus, it could be argued that it was reasonable for Doc to have commenced proceedings against the board within the time limit of 1 year from the date of publication, as that time frame had well and truly come and gone. With there now being 2 separate limitation periods being defined, one beginning from the 30th of June 2007 and the other being from the end of October in 2008, it was now up to Doc's counsel to argue reasonable delay and expiry of both, which of course he completely failed to do. So when the decision of the judge was delivered 2 days later on the 9th of April 2010, the application had been dismissed. Doc's state of mind in not comprehending that the publication of the false statement had occurred, resulting in the expiry of the first limitation period, was not acknowledged. Nor was Doc's financial hardship in the expiry of the second limitation period, which was the true period of limitation and the only one that should have been considered in the first place. This decision was reached despite substantial evidence to prove that in both instances it was not reasonable for Doc to commence proceedings within either of the limitation periods. The first limitation period wasn't legitimate, not only because Doc simply didn't know about the false statement yet, but also because of the second period taking precedence, within which Doc took every possible action to expedite proceedings, having only delayed because he was given incorrect legal advice and couldn't yet afford legal costs for an application to extend a limitation period that hadn't even expired yet. The conduct of Butler McDermott lawyers in handling Doc's case was suspiciously appalling. To begin with, Doc should never have even been represented by them in the first place, because, as it was discovered later, Peter Boyce turned out to be directly involved in the racing industry and was a lifetime member of Racing Queensland. As well as handling legal proceedings against the Chiropractors Board, Doc had also enlisted Peter and his firm to address other matters of defamation by Greyhounds Queensland, where defamatory comments had appeared in the Dogs Online forum, making Peter's handling of the matter a conflict of interest. This was on top of the lethargic manner in which it was handled, with correspondence sent from the solicitors of Greyhounds Queensland not reaching Doc until a month after it was received by Butler McDermott lawyers, even after Greyhounds Queensland's solicitor had prompted them to get a move on and forward their correspondence from 3 weeks prior. It was still more than a week before they finally provided it to Doc. This poor handling of Doc's matters continued on for a further 2 months before Doc had finally had enough and decided to give Peter Boyce and Butler McDermott lawyers the flick. Doc sent a comprehensive letter of complaint to Peter detailing all of the issues of negligence and all-round poor conduct, and that was pretty much the end of that working relationship. Doc promptly complained about Peter Boyce to the Legal Services Commission, as he and his firm were now responsible for thousands of dollars of money wasted in needless legal fees, court costs, and other expenses that wouldn't have needed to be spent if Doc had been provided the correct legal advice in the first place. The matter dragged on for almost 2 years before Doc was able to get a refund of the legal fees he'd paid to Peter's firm for the Chiropractors Board case, but nothing of the Greyhounds Queensland case, and this barely scratched the surface of the losses Doc sustained because of their negligence. Doc continued to press the matter with the Legal Services Commission afterwards, but without any satisfactory result. On top of the obscenely neglectful handling of Doc's case, the fact that Peter Boyce and Butler McDermott lawyers were even available to take on Doc's case in the first place was highly suspicious, given that Doc couldn't find any other legal representation beforehand, and that the only firm that was available to help was in conflict, which is why we strongly suspect that Peter Boyce's involvement was a Greyhound Racing Authority collusion. So was it actually negligence, or was it sabotage? After losing the application to extend the limitation period, Doc wasn't going to give up, knowing that he was again being set up to fall. After Kerry Watson's plan to have Doc sued by the Chiropractors Board of Queensland backfired, you can be sure that the board were none too impressed with the result after having gone out on a limb at Kerry Watson's behest. You would think that that would have been the end of things, and that the board would have retreated and left Doc alone. But instead, they continued to attack Doc by preparing a blatantly untrue and defamatory public statement and posting it online before the court's decision was even handed down, which you would think would only serve to further damage their credibility. So just how much influence did the Greyhound Racing Authority have over the Chiropractors Board of Queensland for them to continue sticking their neck out in such a reckless way on behalf of Kerry Watson? After all the turmoil of the past 5 years being relentlessly attacked by the GRA and the Chiropractors Board, the dismissal of the application and the realisation that it was all a complete waste of time and money was devastating to Doc. At this point, most people would have thrown in the towel, but not Doc Jamieson. He got right back up again and began working on his appeal, self-represented. A few days after the application was dismissed, Doc reached out to Q-Pilch for support. That's the Queensland Public Interest Law Clearinghouse Inc., which is now known as LawRight. However, Q-Pilch were not keen to help Doc because they didn't believe that he was likely to win a defamation case against the board, let alone an appeal to the dismissal of the extension. Earlier in the lead-up to the hearing for Doc's application to extend the limitation period, one of Doc's clients had recommended to him a man by the name of Carleton Thomas to help him with his case. Carleton Thomas was the infamous conman who was later exposed in 2011 as a military imposter after posing as an ex-member of the SAS, and also having committed fraud posing as a barrister and swindling a number of people out of thousands of dollars for supposed legal fees and court costs for cases in which he had no qualification or intention to handle. As the hearing for Doc's appeal case was approaching, Doc was in need of a barrister, and with the difficulty Doc had getting legal representation within the country, this was when Carleton recommended to Doc a judge from Norfolk Island who could act as Doc's barrister, a man by the name of Sir John Walsh. Of all of the legal assistants that Doc has ever enlisted to date, John Walsh was the only person of true integrity that Doc has ever had the good fortune to find. We can only assume that it was Carleton's intention to cash in on the damages Doc would be able to claim for in the event that he was able to sue the board. Less than a week before the hearing for Doc's appeal in October 2010, John Walsh wanted to confirm that Carleton was going to be attending court on the 13th, having assumed that he would have a solicitor available to assist him, as he usually would, but Carleton was not a solicitor, so instead Carleton recommended his own solicitor, Paul Donnelly, to assist. A few days before the hearing, discussions were had between Doc, Carleton and Paul, settling on the agreement that Doc would pay Paul a $1,000 retainer for his attendance in court, and to show his appreciation for Paul attending on such late notice, Doc decided to gift him half a share in one of his racing greyhounds, valued at $5,000. But on the day of the hearing, having not reviewed Doc's case files at all, both Paul and Carleton were of no assistance whatsoever. During the short recess in proceedings, Carleton and Paul left the courtroom for a cigarette break and didn't return until 10 minutes after proceedings had resumed, leaving John Walsh to locate crucial documentation himself, for which Paul Donnelly was paid to do. Despite all this drama, proceedings went well, and it was fortunate that the case was presided over by the same judge as in Doc's case against the Chiropractors Board in 2007. Doc won the appeal and was now free to proceed with claiming damages for defamation against the board. However, Doc was not made aware of the date of the handing down of the decision. Registered in the courts as Doc's counsel, Paul Donnelly was notified, but he never informed Doc, and as a result of not being able to attend, Doc missed out on the opportunity to submit for thousands of dollars in costs, he lost the respect of the courts, and missed the opportunity to have the media canvass his success to help in restoring his good name. Sometime later, Paul tried to bill Doc for a further $6,500 for work he never did. And later in 2011, he submitted to the board's solicitor for some $29,000 in costs, which Doc was never even informed of. This turned out to be an act of desperation after Paul Donnelly had become bankrupt. Stranger still was the fact that after the final hearing on the 13th of October 2010, the handing down of the decision didn't occur until some 5.5 months later, at the end of March the following year, when courts' decisions would rarely take more than 12 weeks. Throughout this time, Doc's name in business continued to suffer, with internet search engines still caching the false statement as the top results when searching for Doc's animal chiropractic services. Another item worth mentioning is that of Dr. Mark Pickford. Mark was the chiropractor to whom Doc used to refer clients to when they were seeking the services of a human chiropractor. When Doc was first warned by the Chiropractors Board of Queensland in 2003 about his use of the term chiropractor in his advertising, Doc had reached out to Mark, who told him that he would liaise with the board on his behalf, having been a board member himself, and sort out the issue for him. Later in October of 2010, as the hearing for Doc's appeal case was approaching, Doc called Mark once again for his support, but much to Doc's surprise, Mark had done a complete 180. During the call, Mark admitted to having been aware of the false statement and had never called Doc to let him know about it. Furthermore, his opinion of Doc's use of the term chiropractor was now completely aligned with the board, of which he was no longer a member. Mark told Doc that he was wasting his time trying to sue the board and that there was no one left to sue after the Chiropractors Board of Queensland had since been reformed into the Chiropractors Board of Australia. But this turned out to be inconsequential as the judge granting Doc's appeal had declared that proceedings would continue against the Chiropractors Board of Australia in place of the Chiropractors Board of Queensland. After Doc's affidavit in 2006 sent directly to each individual member of the board declaring a fine of $500,000 for the misuse of his name, did the Chiropractors Board of Queensland disband in an attempt to avoid being sued for millions of dollars after the false statement had been viewed online hundreds of times? Even though Doc had won the right to sue the board, it was an unnecessarily long road to get there, with Doc's name and business continuing to suffer for a further 3 years after Doc had discovered the existence of the false statement. Along the way, Doc's efforts continued to be thwarted by a saboteur who had managed to become close with Doc and who worked to hinder Doc in a multitude of ways all throughout the application to extend the limitation period and throughout the appeal, as well as all throughout the years of further legal proceedings for defamation that followed, by hiding the medical records of Doc's late GP, Dr. Josephine Drew, who was treating Doc for depression in 2007, records which could have proven Doc's reasonable failure to commence defamation proceedings during the first proposed limitation period, advising Doc against appealing the dismissal of the application, excluding crucial evidence during the appeal, working in with Carleton Thomas and Paul Donnelly, poisoning Doc by lacing his water supply with chlorine, stealing over $100,000 from his bank account, the theft of Doc's motorhome and other property, the destruction of a host of other evidence that Doc had accumulated for not only defamation proceedings against the board, but also evidence in exposing the cover-ups and corruption of the greyhound racing industry, and various other nefarious acts of sabotage. You will be surprised when we reveal the identity of this saboteur in the coming video. How many other people are out there being denied natural justice and being crushed by the corruption of the greyhound racing industry, the legal system, and the regulatory bodies that are supposed to be looking after the welfare of the public? Let us know if you've been witness or victim to the same kind of harassment as Doc. Remember to sign the petition and show your support towards cleaning up the greyhound racing industry. And stay tuned for the next video where we break down the relentless legal games and subversion that unfolded as Doc continued working to sue the Chiropractors Board of Australia for the blatant defamation they enacted on behalf of the corrupted enterprise within racing Queensland.